I have an update for you in the current lawsuits against the ATF and their pistol brace rule, including the nationwide injunction that was recently issued against that rule. So let's talk about what is happening with pistol braces. But real quick, before we jump into this video, I want to ask you guys for a huge favor. The channel right now is just sitting below 600,000 subscribers. I was looking at some of my analytics, and about 60% of all my viewers across the channel are actually not subscribed to the channel. So if you've been watching this channel for a long time, if you enjoy these videos, please consider subscribing to the channel. It will help to not only grow the channel, but it signals to the algorithm that it should push this type of content out to more people so that we can inform more people about the 2A movement and things that are going on that affect our right to keep and bear arms. As I mentioned in the intro, we just got an important update in the ATF pistol brace cases. As we talked about last time on the channel, the ATF is currently trying to weasel their way out of all these cases by claiming that the plaintiffs cannot bring these lawsuits, that these lawsuits should be thrown out because these lawsuits were allowed to proceed forward, it would result in the plaintiffs avoiding paying taxes, which the ATF claims they cannot do. And so the ATF right now is claiming that all these lawsuits are invalid, should be thrown out because of taxes. This is a similar argument to what the ATF made in the Texas Suppressor freedom cases, but the plaintiffs just blew those arguments up in this case, and in their new briefs, the plaintiffs essentially are calling for a summary judgment in their favor and for a permanent nationwide vacatur of the pistol brace rules because no, this does not really involve the payment of a tax. The tax issue is really just a side issue. What is really going on here has to do with agency overreach, which, oh, by the way, has already been struck down by the Fifth Circuit and this court. As you may recall, the ATF recently decided to roll the dice and appeal all the pistol brace cases up to the Fifth Circuit Court of Appeals. Those appeals included the Mock v. Garland FBC case, the Brito v. Garland case, which also dealt that nationwide injunction, which is currently in place. And then you had all the SAF cases, the NAGR case, the GOA cases, which also got preliminary injunctions in favor of those memberships and, the organizations themselves. Now, although the ATF has already lost once in the Fifth Circuit in the Mock case, the ATF has decided to, pick the lesser of evils in their eyes and to appeal all these cases up to the Fifth Circuit, which all those cases were consolidated together and are proceeding forward at the Fifth Circuit level. But despite those appeals, which again were requested by the ATF, the agency is still trying to get the lower court to issue a summary judgment in their favor and have all these cases thrown out, specifically have this Mock FBC case thrown out. The ATF is arguing that this side issue of paying NFA taxes means that these lawsuits are in fact invalid. What this argument amounts to is the ATF claiming that they cannot ever really be sued as long as their required tax stamp is attached to whatever rule under the NFA. Well, then a plaintiff could not bring this type of lawsuit and seek an injunction. The ATF is trying to use the argument that was kind of successful in the Texas Suppressor freedom case, but the ATF made a huge mistake and overlooked a critical fact that was just exposed by FPC. This challenge to the pistol brace rule is not challenging the process of registering an SBR or not even really challenging the aspect of having to pay a tax under the NFA. Instead, this is an APA challenge and a Second Amendment challenge. It is an actual challenge to the legitimacy of the pistol brace rule and this rule which was created by the ATF. The NFA tax component to all of this is really just peripheral, and it really isn't super relevant to the ultimate merits issue which is being brought in this case, and that is being pointed out by FPC. Now, if you aren't aware, recently in the Brito v. ATF case, Judge Matthew Kaczmarek issued a preliminary injunction which blocked the pistol brace rule in its entirety while this case is proceeding forward. And that issue by Judge Kaczmarek was a nationwide injunction which springboarded off of another decision by Judge Reed O'Connor, in this case, Mock v. Garland. Now, the Mock case and the Brito case have been appealed up to the next level, but what the ATF also decided to do was roll the dice at the lower court level, and right now they're asking for a motion for summary judgment, and their primary argument right now in the lower court is taxes. They make an argument that this lawsuit is barred from being brought or reviewed by any court because the plaintiffs aim to obstruct the collection of the NFA's required taxes. That's right, they're arguing taxes. They're trying to use the NFA tax requirement to protect themselves and avoid these lawsuits. They claim that under the Tax Anti-Injunction Act, Americans cannot sue the ATF to stop the pre-enforcement of the rule. Instead, the ATF argues that the AIA requires individual taxpayers to go through the NFA process, register their braced pistols as SBRs, and then seek a refund from the Attorney General if they don't like that. And only if the Attorney General's office denies the refund can the individual then file a lawsuit for recovery of the taxes that were paid to the ATF. So they're saying there is a very limited administrative process for lawsuits, but you can't bring these types of lawsuits, which FBC has won, GOA has won, SAF has won, the Brito case won. They're saying that all these lawsuits are invalid and must be thrown out. This, of course, is an absurd argument, but what they're trying to do is use a similar argument that they made in the Texas Suppressor Freedom case. The ATF made a similar argument, to why the plaintiffs in the Made in Texas Suppressor case had no standing, and the lower court did buy that argument and dismissed the case for a lack of standing. But the ATF actually made a huge error. The Texas Suppressor Freedom lawsuit case was based on the law which was passed in Texas. That was a law that Texas made. It was the Made in Texas Suppressor case that allowed Texas residents to not have to pay the NFA tax, not go through the NFA process, not have to register those items going through, the NFA requirements, because the argument there was that these Made in Texas suppressors, which are made from items exclusively within the state, don't leave the state, they don't affect interstate commerce, and therefore they fall out of the purview of the ATF's regulation of those items. So it was a law that was structured very specifically against the NFA's process and also the NFA's tax. That Texas lawsuit in many ways directly challenges the NFA's process and the tax requirements. But these pistol brace challenges here, which we're talking about, do not actually do that. Instead, these are challenges built on the APA and also the Second Amendment, which they argue that the ATF never had authority to create this rule ever. This is not within the ATF's authority. Any impact on the taxing component really is just ancillary. It's just a side issue and is not at the core of what's really being challenged in these lawsuits. And because of that, an FBC's brief against the ATF and their recent arguments just completely obliterates their new position. FBC states in their brief that the agencies offer one new theory that the Anti-Injunction Act, the AIA, bars jurisdiction over this case because the National Firearms Act imposes a $200 tax transfer on all firearms transactions that are properly within its coverage, and the final rule would massively expand that coverage. The AIA does not apply here, principally because the relief sought in this case is not directed at the acts of assessment, levy, and tax collection themselves. Rather, plaintiffs seek vacatur of the final rule and an injunction preventing defendants from enforcing or implementing the final rule. This suit contests the validity of the final rule under the APA. The relief requested does not target the NFA's transfer tax. This case has, at most, a tangential and incidental impact on the government's taxing power. So the AIA has no application here. They state that the court should enter judgment in plaintiff's favor on all claims, vacate the final rule, and issue a complementary permanent injunction enjoining defendants from treating braced pistols as rifles subject to the NFA. So the ATF decided to throw up a Hail Mary, argue taxes, but it's not going to work. In all reality, I think the ATF is just completely scrambling in all these cases. They were kind of grasping at straws. One of the successes they kind of had in a different case was the AIA, was taxes against the Made in Texas Suppressor case, which again is still being litigated right now at the Fifth Circuit level. So although they won in the lower court, that's still a question which the Fifth Circuit is grappling with. That whole AIA issue is in front of the Fifth Circuit as well. So, the Fifth Circuit could also hand another loss to the ATF at a higher court level on Made in Texas Suppressors and taxes. But again, the ATF is just grasping at straws. They're backed into a corner. They decided to argue taxes, but FBC went through and showed that this really doesn't involve the NFA's tax. That is kind of a side issue. This is a challenge to the actual pistol brace rule, which was passed and put into place by the ATF. They overreached. They went beyond what authority they actually have, which again is an issue right now that the Supreme Court is also dealing with Chevron. This is something that the ATF went beyond their scope of authority, put in place this rule, and now they're paying the penalty. So that's what's going on right now with pistol braces. I know a lot of people are curious about what's going on. There are still those nationwide injunctions, which are protecting under the Brito case, and then you have the more limited scope relief under FBC and GOA and a lot of their membership wins. So there's kind of double layer protections right now for those who are just curious about the current status of braced pistols. We still have those injunctions in place, but this is something that is going to be very dynamic. It's being argued, it's being litigated at multiple levels in multiple courts. So as we get more information, if anything else develops, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm. and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.